hope that somebody who is more normal will come out and say some normal remarks. So I speak in support of 55(1)(a).
Mr. Silichung, Mr. Wang Guoheng uses famous quote, day and night, night and day, continue to fight. Now we need to rest, and we can also use a soft approach to deal with tough matters. Now, the Select Committee is to buy time, but it will be useless. In recent weeks, I met with the netizens. I met with the copyright owners. They all know what they want. Their positions are very clear. That is just a little bit to bridge the consensus. I met with the copyright owners. They want the bill to be passed. That will be important to their own interests. They say that in the past few years they gave in 6 times. And how many times will they be required to give in? It is impossible to give in forever. That is still a way, that is still an opportunity to negotiate. When the Select Committee can complete the work, you need the participation of the copyright owners. We don't know whether they are willing to participate or not. If they are unwilling to join the discussion, then the setting up of the committee will be meaningless. As netizens, I met young people, I met the frontline, keyboard frontline. They are fully aware of what's in the bill, and they know that the bill may not be applicable to them. They are the users. But I tell them that in the future, when they set up their own companies, when they do creative work, they may become a copyright owner. And then they will discover that there is no law to protect them. So it cuts both ways. They understand that, but they have also openly said that they don't trust the government of this term. So who will you trust? I asked them. Well, if the CE is Audrey Yu, then they will trust her. They will accept the bill, lock, stock, and barrel. Well, if the current term of the government is Audrey Yu, but next is CY Leung, then what? We cannot just put our trust on the person. We should put our trust on the mechanism. Now, the judiciary is still independent. It doesn't mean that if someone prosecutes you, you will certainly be convicted. They know that it's impossible to have all the 3 amendments passed, and they cannot accept and they finally accept that they can accept just one of the amendments. They raised this, and then I put it to the copyright owners and let the copyright owners think about it. As for the administration's handling of the matter, the administration has to reflect on this. The message is very clear. If my memory serves me right, when the Finance Committee was studying the funding for NT-Northeast, some netizens suddenly raised this point. That there was the issue of Article 23 of Internet. There was somebody stormed the council building because of the wrong message. The electrical building was stormed. The administration should have noticed that this bill would not be so simple and could be passed easily. The administration has underestimated absolutely the impact of the bill. But whether the matter should be dragged on, is another thing. If a consensus can be reached within the short term, then I believe there's a chance that this bill can be passed. The netizens understand this. Now they have made an offer. They just want one of the 3 amendments. If the copyright owners can accept this, or if there is a counter offer and finally there is a consensus, then just within a short term the bill can be passed without any disputes. This is not easy. It's easier said than done. But do the copyright owners want this? If they don't want it, then they will not have it for the next 5 years. Is it good? Is it in the best interest of the copyright owners? If a consensus can be reached, then absolutely, that's absolutely a win-win situation. Though it is quite remote, but we still hope that there can be a breakthrough.
Mr. Lee again. Mr. Deputy, first, I believe Mr. Wong Kwok Hing should apologize to Ms. Sit-ho because what he said was not true. He censored or he condemned Ms. Sit-ho for being hypocritical, saying that she didn't really care for the amendment bill and she just at the very end became bold. And he claimed that Ms. Sit-ho withdrew from the BC halfway. Now, let me tell you who actually withdrew. In fact, it's Chen Yunhan in front of you and Alice Mack sitting next to you. They are those who withdrew from the BC halfway. You want to censor them, you censor them. Now, I don't want to censor those who withdrew from the bill. It's Wong Kwok Hing who wants to do so. Ms. Ho has never withdrawn from the bill. When you speak, you should tell the truth, because in this council, you cannot be sued for libel and you like to make distorted remarks. So I think you owe Ms. Sit-ho an apology. And he said that Yokman was very bold. He was able to make clear his motive. So have we. We have explained why we have called for comm so many times, because we don't want the bill to be passed without the amendments. We have been very frank with our motive and position. We want to resolve the conflicts between the copyright owners and the netizens. We want to have amendments so that the amendment bill will not be a sword dangling on the heads of netizens. So you framed us by saying that we haven't, we've been timid and we haven't been very honest with our motive. No, we've always said that we want a balanced bill which can protect the netizens, not like the administration's bill, which is biased towards the copyright owners. We've always said so. When it comes to ROP 51A, you and even Gregory So have been second-guessing our motive. You say that we are moving this motion so as to filibuster. Well, this is not really the case. For the previous moves, yes, we were filibustering, but for the proposal to set up select committee is a move to resolve the problems. Now, if you pass this motion, at once we can have the select committee. Why should we have this? I think this is a wisdom of our LP, and we've never invoked this before. This is because when it comes to the second reading, well, something might have happened, and therefore there is 51A and 51B. Well, for 51A, there's a new development. Now, under the ROP, we cannot discuss principles in the select committee, but the details, because the devil is in the details. The details are the amendments. So if we can agree on the amendments, then the whole thing will be resolved. And that's why we ask for the bill to be committed to a select committee. The LOP give us room for issues to be resolved, and we want to make use of this room. And 51B gives the chairman room to rectify problems. If he's of the opinion that the bill will specifically benefit or otherwise specifically affect some particular person or association or corporate body, then he may direct that the bill be committed to a select committee. How come we have this provision? Because a lot of things can happen in the world, and if there is no room to maneuver, the bill may be passed, and therefore ROP 51A and B are written here to allow flexibility. Grexo said that we're just filibustering in disguise, but this is not what we want. If this motion is passed, it will be a way out. So you should think twice. Pro-establishment members, do you want to resolve the problem? We've made it very clear that the amendment bill itself is biased towards the copyright owners. So I'd like to ask FTU, Wong Kok Heng, what is your class position? You talked about betraying the interests of workers. These workers are netizens. How many workers are copyright owners? Where is your class position? You betray the workers together with the administration. You are biased towards copyright owners. You want workers to be sued with millions of employees in Hong Kong, and all of them are netizens. So when it comes to shamelessness, who is shameless? You've forgotten your position. This is FTU. I hope Wong Kok Heng can clarify what Mr. Wong Kok Heng said just now. He's outrageous. He said that under a strong general, there are no weak soldiers, and presidency are saying that in hard times you can see the strength and resilience of a person. This is bootlicking. Well, CY Leung owes us standard working hours, universal retirement protection, and abolition of the offsetting arrangements. You are bootlicking. You are praising CY Leung. I don't know what is your real position. At times, you call CY Leung disappointing, and at times you praise him. You cannot stop me, Mr. Deputy. He has said for so long you didn't stop him. You have plenty of time to respond, but I just want to remind you that you have digressed. I am explaining why. FTU should explain or should support the committal to a select committee rather than resorting to all sorts of arguments saying that we are filibustering. We want to resolve this stalemate. I am reminding FTU that it should stick to its stance. It should not be biased towards the Leung administration, because the Leung administration and Mr. Grexo is against standard working hours. If you think that CY Leung owes you universal retirement protection, standard working hours, and the offsetting arrangements, and they have let you down. They have let FTU down, and it is outrageous for you to sing praises of CY Leung. So my question to FTU is, do you really want to resolve this issue? Wong Kok Heng talked about having meetings around the clock. Are you going to torture the staff with such meetings? Now, did Wong Kok Heng represent the FTU? If so, you can issue a joint letter. But on behalf of our side here, we ask you not to torture the staff in this way. Meetings around the clock, day after day. Now, I hope you won't be emotional. You should really ask yourselves whether you want to have the issue resolved. Carrie Lam once said that she was thinking of withdrawing the bill, and then another day, and then afterwards he denied having said so. So she's also undecided. I think this motion is a way out for the administration, for Carrie Lam, and for Grexo. the pro-establishment camp talked about making a day tour. Yes, making a day tour is even better than going into a dead end. The pro-establishment camp should support this motion. A select committee will break the stalemate. And yet, you would like to be on the side of CY Leung. I think what Wong Kok-heng's remarks showed that he liked to start struggles like CY Leung. And all of a sudden, he also scolded the public PWSC. Do you want importation of labor? Yes, for some projects to go ahead is good, but if all the projects are started in one go, then eventually we'll have to import foreign labor. Now, we have told the administration that for the controversial projects, we should shelve them first and deal with the non-controversial projects. Well, how come you allow Wong Kok-heng to digress and not me? I've reminded him, and I have the duty to remind you. But he scolded me. When we talk about labor, is a departure from the topic. So we really want to resolve the matter. Please don't frame us and drag public works into the question. We want non-controversial public works projects to go ahead first. Coming back to the question of a select committee, we have come up with a proposal. Professor Peter Yu said that there is a new way. So apart from the 3 amendments, we can discuss Professor Yu's proposal. And that is an injunction, civil and criminal injunction. It prohibits any civil and criminal actions against individual users, not for commercial gain. So have you considered this possibility? Can you heed the advice of a scholar? Because this will rest assured the netizens, and this will also not remove all the safeguards for copyright owners, because we're talking about non-commercial infringement activities. So commercial infringement activities will not be included. Netizens, there is nothing commercial in nature when they share things. And this is not saying that the conduct of netizens is lawful. As you can continue to sue the intermediaries. These things can also be removed or cancelled. So on the one hand, there is protection for netizens and the intermediary platform, and also copyright owners can resolve their differences by civil or legal actions. They can settle a commercial dispute with cash. But for netizens, they will not be affected by any civil or legal or criminal actions. This is the purpose of the select committee. Obviously, we have a conflict in view that cannot be resolved. So there is a way out. The question is whether you're willing to consider that. Wong Kok-heng engaged in this very confrontational attitude. He doesn't want the matter to be resolved. Then I can say nothing about it. But we are proposing a way out under ROP 51A. And then there are 3 amendments in question. Copyright owners and netizens can sit down and discuss the possibilities, and there is a new proposal. This netizens will be free from legal or from civil or criminal actions, and copyright owners and intermediaries and these platforms can then work it out. For Netflix, if you pay $78 per month, then you can use Netflix, and this will resolve the problem of streaming. People can use Netflix lawfully. So there are plenty of ways for copyright owners to continue to do business and expand their business. Whether you call us filibustering or not, the purpose is not to have netizens inadvertently caught. Please don't forget that there is criminal liability. Of course, the administration likes to say that they will not prosecute easily, and it's up to, there must be complaints from copyright owners before netizens will be prosecuted. But these are just your words. What if a netizen is sued or prosecuted for infringement, although he has no commercial interest involved? So pro-establishment members, please consider whether you want to be party to this very difficult situation. We don't want netizens to be intimidated or to face this threat of prosecution. And let me remind you once again that there are 18 bills waiting to be tackled, and I think we should have the general good in mind. And you should support 51A so that there can be a way out instead of engaging in this struggle. Thank you.
Mr. Porter, Mr. Deputy, those who have taken part in the discussion of the bill and the government department will go down in history as sinners in relation to this bill, then I'm afraid that, many people will be named as sinners. Ms. Sito said that we started having the copyright ordinance in 1997. Actually, before 1997, we did have copyright ordinance, and we're just copying from the British law. And it's not like what Mr. Kwok-Kee said. We have good records in copyright protection of IPs. And when I first started as a barrister, the copyright infringement acts are very rampant in Hong Kong. In the cases that I dealt with is that there were many cases related to copyrighted infringement works, and we sought for injunctions to close down business. So we did have that in the past. But in recent years, our economy has developed, our awareness has heightened, and people are becoming more law-abiding. So that's why Hong Kong is building up its reputation gradually in that front. But we've come to this stage that the existing legislation cannot deal or cope with the present technology, especially when there are loopholes in the law, in that we cannot deal with infringement acts on the internet without reproduced works. If we don't have a way out, we don't have a selection, we'll be lagging behind. As what some members said, Hong Kong's creative industry will be dealt a blow. I might have reservations on that, but since we've gone over the past second reading, I will not dwell on this. Now, on this motion, is this a way out, a detour, or a way leading to the dead end? I think we have to have several considerations. Let's take a look at the motion first. Well, this is a select committee or ROP which has not been tested before, which has not been invoked before. Raymond Wong has been working hard to go back to records to see why we did have such a rule. But I'm afraid that this rule has never been invoked. Well, at least not after 1997 in dealing with motions. It's not that there's no reason for that. The rule itself may not be able to address the issues. It's just referring the issue back to the original place. And in 56.1, we can see that this bill to be committed to the select committee. The discussion should only be held on its details and not on the principles. Well, there might be a lot of debates on what is details and what is principles. But I think for any major bills, principles will be involved and not just the details. everyone here thinks that they have their own principles in relation to the exceptions in particular, and those opposing the bill, they have their own principles. So I'm afraid that if the Select Committee is really established, I don't think it will resolve differences of opinions and principles. Then we might start all over again. Second, 61, 3, and 4 of the Rule of Procedures. So it seems that after the Select Committee has been set up and its work is completed, we can get back to the third reading stage. I'm afraid there have to be several procedures to be gone through first. Mr. Deputy, if the bill returns to the full sitting, some members may still can raise that the committee stage still be held. So I don't think that's a shortening the way, and it will not be able to stop members from moving amendments and motions again at the whole council when the bill comes back to us after the Select Committee. So I don't think this is a shorter way. Even if there is we have gone through this detour, then we might be heading towards the dead end still. So Mr. Tankap, you mentioned something that I would like to repeat here. Well, this has never been invoked. But if we examine the pros and cons, we think that there are more pros than cons. Should we give it a try? I would like to thank Mr. Tang's observation, and that is whether there have been significant changes in circumstances. Well, these are considerations that we usually bear in mind in dealing with cases in court. And after certain procedures have been completed, then we will look at whether there are significant changes in the circumstances before dealing or making decisions otherwise. Now, should we be overturning what we've done because there have been significant changes? I think this is something we should consider. But I've read through the views expressed by netizens. They've proposed major amendments. Actually, these major amendments have been deliberated, studied at the Bills Committee. The Bills Committee has taken reference from overseas literature, and the decision ultimately is that these three proposed amendments should not be accepted. And also Mr. Lee Chak-yan quoted Professor Peter Yu about the criminal civil injunction, and Mr. Albert Ho termed it as the collective exceptions. Well, this is no strange concept to us in copyright cases before, especially when there are licensing schemes involved, and there may be exception for collective scheme participants, and the operators of the collective schemes may have to protect that the participants will not be sued, and in certain cases there may be civil criminal injunctions to be taken out. That there have been cases like that before, but the question is how we should apply to our present case. The most contentious issue here is for the copyright regime. Well, that has been evolving over the past 100 years, and we need to amend the legal framework from time to time to cope with the technological advancements. I remember that when I started out as a legal practitioner, there was never the concept about moral right, performance right, and so on. These concepts have been added on later on. But then we are talking about the communication right this time. This is a very important development. I do admit that, acknowledge that. So that's why we have to tread carefully on that. But it doesn't mean that because we have controversies, we should not take any further step. Well, before Christmas, I voted in support of whether to adjourn the proceedings. And members asked me why, so I have to set my stance clearly here. I voted in support because we really would need some more time to allow the various sides to come to a good solution. But unfortunately, in the past several weeks after exchanges with them, my observations, it seems that, well, actually there is no feasibility of coming up with a good solution. And I think further discussions will cause further drifts and controversies in the society. Going by my experience in civil or lawsuits, I hope that the different sides can negotiate and come to a conclusion and reach a consensus. But then we know that there may be a certain point where we know that there will not be any negotiation, and we have to fight till the end and get a ruling from the courts. Well, for a civil case, but for the electoral, it's a voting decision has to be made. But I think it's we've come to the stage in the electoral that we should not be resorting to any proposals which will further delay the discussion, but which would not be of any help. Now, if this motion is passed, I'm afraid that the copyright bill will only head towards the dead end, and it's impossible for the bill to be passed within this legislative session. And in fact, it's killing the bill. So I think we should proceed ahead. I don't agree with Mr. Wong Kwok-hing that we should hold meetings round the clock. Even if we do that, we may not pass the bill. But then if we vote in support of this motion, I think we're just heading towards a dead end. So I don't think it's right for me to support the motion. Mr. Deputy, many members, in particular Mel Albert and Sid Ho, have said that they've come up with new concepts upon which we should support the motion. Let me try to respond to their points made. On Wednesday, in the oral question session, the government official responded to Mr. Raymond Chan's question on the CY Lang's uploading his song singing video onto the Facebook. In the reply to the question, there was a point quoted by Ms. Sid Ho. Mr. Porter, I think you're digressing. Please come back to 55(1)(a). Please let me explain, Mr. Deputy. If there are new circumstances or significant changes which have not been considered at the Bills Committee and which warrant our further study, that may be one reason why we should support the motion. And one of the reasons cited by other members is that in this reply, it is said that whether someone is breaking the law, it depends on not only the circumstances, but also whether the copyright owner will take somebody to court, take action against a user, and the ruling of the court in any subsequent litigation. You may recall that, Mr. Deputy. Well, I don't think that's a new concept in the bill. I think it's just stating again the common law principles. And that is why that will not be considered a breach of the law. In common law principles, and that is, say, for example, the criminal liability should be proved beyond doubt. And this is always set out in the common law. Mr. Albert Ho, he is a lawyer. He should be well aware of such principles. So the same goes for the copyright bill. We should also be looking at examples of copyright lawsuits. Sometimes the actions of both parties may, say, cause an implied license And there may be a concept called estoppel, because somebody may remain silent for a long time, then that will constitute an acquiescence. So these are the basic or important principles in the legal sector. So if you are in the field, you should be well aware of them. So I'm raising this not to say that this is not a new concept in the bill, and that warrants that and a special committee to be set up to look into that particular point. So, Mr. Deputy, thank you for allowing me the time to raise this point. And really, I don't see any significant reasons or significant changes in relation to the principles and the law and so on, that warrants a special committee. And also in 61, it says that we are not going to discuss the principles for details. Thank you.
Members, if no other members ask to speak, then I will adjourn after Dr. Fernando Cheung. Well, I'll adjourn the meeting after Mr. Abraham Sheikh. I don't draw the line. Well, this will continue next week. Dr. Fernando Cheung. Thank you, Mr. Deputy. The debate before us is whether we support the motion moved by Ms. Sid Ho under 55(1)(a), which is to commit the bill to a select committee to further study the bill, to deal with controversial issues and to deal with issues which need further clarification. We have seen very strong reactions in the community. There are many outstanding issues and consequences of the bill which have not been dealt with, and therefore we want a select committee to resolve all these issues before we reconsider the bill and pass the bill into law. This approach is absolutely a way out. And our predecessors have shown their wisdom by putting this in our rules of procedure. When a bill is put before this council, and the bill has caused strong reactions in the community, then we have this opportunity to put aside this bill, reconsider this bill in detail. Instead of allowing this bill to block the work of this council, we have a mountain in front of us, blocking our way. If you want to climb over the mountain, it will be very difficult, and we have not seen a road. But there is a road to get round the mountain. And finally, we can reach the destination. The road may be longer, maybe a bit longer, and we may need a bit longer time, but there's still a way out. What's the problem? That is exactly the opportunity, the way provided by the rules of procedure. If you find it not reasonable, then is the rule of procedure, is this rule of procedure unreasonable, and should this rule be deleted or repealed? If that is the case, then you have disregarded the good intention of our predecessors. They wanted to leave some room, leave some space for discussion. Mr. Paul Che's argument was that there was no serious incident or strong justification for giving the bill to the select committee rather than allowing the bill to be considered by this council in committee. I have not seen any important public interest which supports the present logjam. This bill protects the rights of copyright owners. I do not see how serious and how urgent It is that if we don't pass this bill, Hong Kong cannot move forward. There is no such justification. There are a lot of bills outstanding. Say, Carrie Lam referred to 18 bills waiting in the line. And we have only not too many sessions, electrical sessions left, electrical meetings left. And there are also many social incidents, Mr. Deputy. And we are very concerned about it. Say, for example, the Causeway Bay bookshop incident, the TSAs issue, and also the link is raising rents in markets and shopping centers substantially, and the shop operators are suffering. The store owners are suffering. Within half a year, there were 20 suicide attempts by students, and 15 students died. We want to bring these issues up in our council. Now, concerning the subcommittee on domestic and sexual violence, we are drafting a report, and we want to get a time slot to debate the report in this council so that the whole council can adopt our working report. This is very urgent. In our report, there are many recommendations which will have a bearing on people's livelihood, an important bearing. This is this is a place to deal with urgent issues, and we should discuss these issues. But this controversial copyright amendment bill is before us, standing in our way. And there are very different views. There are less members who oppose the copyright amendment bill in this chamber. If we are to stop a bad thing to happen, an evil thing to happen, then we can only make use of the rules of procedure to deal with that. 55(1)(a) is a solution. It's not that the bill will be silenced. It is to commit the bill to a select committee for further discussion. Why? You only oppose anything we propose. That will be a dead end. Mr. Deputy, we are not far away from the appropriation bill, the budget debate. We have many amendments under the copyright amendment bill. If we keep speaking, yes, we are making use of the rules of procedure to drag the matter on. Filibustering, yes, filibustering. If filibustering leads to consequences on our part and be penalized by voters, then in September our voters will penalize us. We know that fully. This is a draconian piece of legislation. Mr. ll.Hong, I suspect that there aren't enough members to make a quorum.
石禮謙唔講。請各位同事坐低。
Would members take your seats, please?
Okay. 由於傳召議
Now the 15 minutes for summoning members have passed. We don't have enough members to make a quorum. I adjourn the council until the 27th of January at 11 a.m.